The Small Business Reorganization Act is perhaps the most intelligent single piece of bankruptcy legislation that Congress has ever enacted. It permits a company or an individual with less than $7.5 million of debt to confirm a Chapter 11 plan economically and quickly. There are many advantages to the SBRA in subchapter 5 of Chapter 11. It requires no disclosure statement, no creditors committee. There is no absolute priority rule. And furthermore, the subchapter 5 trustee is the debtor's friend and helper, not adversary. Some courts, however, have been rather restrictive in who is eligible for the SBRA. Some courts have held that you have to be currently involved in business to be able to reorganize under subchapter 5. Well, bankruptcy judge Thomas McNamara from Denver came up with a novel approach that will allow many debtors to be eligible for subchapter 5, even though their businesses are defunct and no longer operating. The novel approach by Judge McNamara said that, well, even if the debtor is flipping hamburgers, that is, by working in a fast food restaurant, that debtor is engaged in business. And that by itself is the first step toward authorization to be in subchapter 5. He went on to say that, of course, that's not enough because at least half of that person's debt has to have arisen from operation of the business. And so, because in the particular case before him, the debtor had more than $6 million of guarantee debt on his defunct business, Judge McNamara allowed that individual to continue in subchapter 5. Well, I must admit that the decision by Judge McNamara is probably somewhat at the extreme, and I'm not sure that all courts are going to follow it. Many will be more restrictive in saying that no, your business must be currently operating to be eligible for subchapter 5. Nonetheless, I think those courts that are more restrictive are not reading the statute as it should be read because, frankly, if you have to still be operating, that's going to exclude many people from subchapter 5. One of my acquaintances, who was in fact involved in the drafting of subchapter 5, believes that you are eligible and you are still involved with business if you're trying to reorganize your old debt through subchapter 5. And this individual would allow somebody to be an SBRA debtor when your purpose is to restructure the old debt from a defunct business. I am Bill Rochelle, the Editor-at-Large for American Bankruptcy Institute. I will return same time next week with something interesting about bankruptcy. Until then, be well, enjoy the spring. Good day.